It appears this week's High Court judgment that President Cyril Ramaphosa could be personally liable for the Marikana massacre damages has been lost in translation. Well, the survivors of the August 2012 mass murder in the Northwest demand a compensation in a class action lawsuit. However, the presidency is adamant that the court actually ruled in favor of Ramaphosa's argument that he owed no duty to care towards the survivors. Well, the EFF, meanwhile, believes that the president now has a case to answer, while lawyers for the survivors maintain Ramaphosa could be held liable for damages. Joining us now to bring some clarity on what the judgment actually says are Andries Nkome, attorney for the Marikana survivors, and legal expert Benedict Phiri. Gentlemen, good afternoon, and thank you very much for your time and for joining us today here on In Focus. The plaintiff, my understanding, and you'll correct me here, instituted action against President Cyril Ramaphosa as the first respondents and Sibanye second respondent, and I think government as the third respondent, seeking payment in respect of patrimonial and compensable loss suffered as a result of the faulty conduct of both 1, 2, and 3 defendants. Okay, let's say that in English. What does that then mean? Andries?
Good evening and thanks for having me. What that means in plain English is that the plaintiff says, or our clients say that the reason why they suffered damages, the reason why they were murdered and injured and arrested and detained was as a result of the actions of the 3 parties that are mentioned there. Cyril Ramaphosa in his personal capacity, Longmin, now Sibanye Stillwater, as well as the government. And we also know, I think, that all the parties have entered an appearance to defend. They've said they defend this, but government has accepted liability. And I think the discussion now is supposed to be about the judgment that took place now in the past week. And right. I think we can come to that later, yes.
We're going to come to that in a moment. So I want to understand, I want to go very slowly here. And part of what you're saying then also in your pleas is that the 3 defendants acted in concert amongst each other as principal players in the collusion between the state capital, which resulted in the massacre. So what are you basing that collaboration on? My understanding is that you're basing it on email communication, one, but also telephone conversations. Is that what you presented to the courts?
Yes, we base our submissions, our conclusions that the Marikana massacre took place as a result of a toxic collusion between state and capital on the evidence that we had, which is consistent with what we presented in front of the Falam Commission. We've always been saying, had it not been for these 3 parties colluding and trying to stop or trying to characterize a labor dispute as a criminal act, there wasn't going to be the result that ensued. So therefore, it's always been consistent, and we are glad that the courts are slowly getting to an agreement with us in that respect.
All right. Now, it gets exciting and interesting here, where then the defendants are bringing multiple exceptions. Benedict Phiri, let's bring you in here. As a principle in law, exceptions, what is that and how does that work in terms of the conduct of law in this country, administration of justice?
Yeah. So when we talk about exceptions, essentially what we're talking about is we're saying a plaintiff, in this instance, the Marikana workers have brought a case. But when you look at their papers and you look at the allegations that are contained in their papers and the facts that they are using to try and substantiate the conclusions in law and the relief that they seek, there's a mismatch there. So either, the allegations are vague and embarrassing in the sense that they're not coherent, or maybe mutually destructive in some instances, in such a manner as wouldn't allow a defendant such as the president or Lonmin, Sibanye Stillwater, and the government to actually respond to those allegations. Or you are saying that actually the allegations don't disclose a valid case in law. In other words, you haven't pleaded an essential allegation that sets up the liability, or you haven't pleaded a case that is actually allowed in our law. So that's really what we're talking about when we're talking about exceptions. And what the President Ramaphosa did in this particular matter, he raised a number of exceptions relating to those two particular areas, saying there are instances in the papers where it's really hard and really difficult to work out what is the case that I'm meant to answer. And secondly, there are instances in the papers where the law just doesn't justify the relief that is sought by the Marikana workers. And the court in this particular instance actually upheld all the exceptions barring one. Yeah. And obviously the effect of that is that then the Marikana workers must go back and fix the papers so as to bring them into a form that the defendants can answer to those papers and bring them into a form where they've actually set up a case that is valid and allowed in South African law. Yeah.
Let's quickly deal with 6, 7, and 8 exceptions, which really have got to do with the court finding, I suppose, the president, determining what the compensation should be. And the court's pretty much saying it's still early at this stage for me to issue an order on this, on compensation and that kind of thing. So that is essentially meaning that that is parked for the moment, pending what you've just clarified, that the plaintiffs would need to now resubmit their case in a different kind of way.
Yes, and just to be a little bit more precise in my first response is that there was an element in this matter which related to compensatory sort of damages or punitive damages which are linked to the Constitution, which the court felt, didn't need to actually decide the exception at this particular point in time, given the complexity of the legal principles that might need to be traversed with that respect. And the court said, well, we can park this for a later stage in the proceedings, assuming that, for instance, the exceptions around whether the president in his various capacities as a director of Lonmin, as a BEE shareholder, as a BEE representative, actually owed a duty to the Marikana workers in that particular respect, or whether actually the Marikana workers had shown that his conduct with respect to these emails and these telephone correspondences he had with the senior leadership in the police was actually close enough to the conduct and the harm that actually ensued on that day. And really that was where the crux of the exceptions turned with respect to those two particular areas, where the court was like, well, it's not really certain that these emails firstly originated from the president insofar as inciting harm, and secondly, whether they actually were of the nature that they incited harm, and secondly, the correspondence between the president and the leadership of the police, at least what was in the papers, did not suggest what the Marikana workers were asking the court to find. Yeah.
So the first ground of exception that was upheld, Andries, is particularly that. And it's been argued over and over the years, this idea of concomitant action, meaning that the miners must be murdered. And the court's saying, no, we don't agree with this idea. The proposal that concomitant action was required to be perpetrated against them meant that they meant to be killed. And similarly, you're pleading, saying that you added some words. There's some text that was actually not in the email. Explain that to me.
Okay, look, I think maybe let's go back to a bare basic definition of an exception. Because I think from the explanation that has been given, already it carries some deviation from what the ordinary exception is. An exception is an objection that is raised by a defendant on the basis of which he says, I wish to have this conclusion arrived at by the court, failing which, or this particular sort of claim of a plaintiff arrived at, failing which the plaintiff's claim must be dismissed. Now, if one of the exceptions has been dismissed, it therefore means the plaintiff's claim must continue. And I think that is where my fellow panelists misses it. Inasmuch as there might have been 100 exceptions raised by Ramaphosa, for the fact that the court says, we accept and we want to have one dismissed. Therefore means the plaintiff's claim must continue, and Ramaphosa will have to sit in the witness box and be cross-examined. Now let's go on to the current exceptions which have been dismissed by the judge. The judge says, at paragraph 41, I find that there is factual causation in respect of the actions of the first defendant, which is Ramaphosa. So there is a factual reason why a court would conclude that his actions caused the result which has been arrived at. And I think the same also is said at paragraph 42, where they say that there is a legal causation. It means legally there is a basis for Ramaphosa to respond to the particulars of claim as has been set out by the plaintiffs in their claims.
All right. But my understanding of, because you've now decided to go on the third ground of exception, so let's stay there. The issue that was being canvassed there, or at least that you were pleading there, is that the first defendant put pressure, literally, on the arms of state. In a sense, and one of that, it's saying that you were trying to say that kind of pressure is what caused the action, and the judge saying, well, there are two areas that you prove causation. One is factual causation, and the other one is legal causation. Explain to us then what you managed to do there in terms of factual causation and legal causation to prove your point.
You would remember that the very same submissions that we made in front of the judge in the South-African High Court were the same that were placed in front of Judge Ian Falam. Say for that, in his conclusion, Judge Ian Falam did not come to a conclusion that says the characterization of the labor dispute was what caused the massacre. And we have been able to prove in front of both Falam as well as the court in Joburg that immediately after the acceptance of the characterization, after the pressure had been exerted by the then deputy president, the police acted in a pointed way in making sure that, one, they let go of their orders of rubber bullets as well as water cannons and the pepper sprays. But then they decided to go and order live ammunition. They also decided to go and order mortuary vans instead of ambulances. So there is communication that we have, which we, at a trial stage, will be able to prove that there was communication to the effect that the expected number of people to die after that characterization had been made was 20.
Right.
And it's only a pity that 36 went on to die. So therefore,
but then to be clear, it was not required of you at this particular point to prove that, right? You will need to prove that during trial. For the purposes of what you were dealing with here, you did not present that kind of evidence to this court.
It is a bare basic. When you deal with an exception, the court says, I accept the allegations as you have made to be true. And then thereafter, the defendant are the ones that are supposed to come through to prove that there is no sufficient particularity to sustain a particular allegation. But it's for us, and we are glad that at this stage, the court has accepted this. More evidence will be put up to the president simply because this time around, we've been able to get him to come through and testify.
For the purposes of this then, Mr. Phiri, is that sufficient to then establish that then the president can be held liable? I mean, no evidence to that effect, and probably will be put before the trial, but even the writing is saying that the plaintiff will at the trial be able to maybe prove or not prove these allegations, but at this particular point we accept. Does that then mean there is a prospect of a president being held liable? Because many people have read that to mean that is exactly what it means.
No, I don't think it means that, because as my fellow panelists have said here, the court goes into a hypothetical test. It says, if I accept the allegations you've put in your particulars of claim as they are, have you set up enough of a case for the respondent to respond to? It's a hypothetical scenario test that the court goes into. So we know in respect of the exceptions that were denied, that the court said, when I look at what you've said on your papers, you have alleged enough facts and you've alleged enough facts that would support a conclusion in law that potentially there's a case for the president to answer on these particular aspects. And I think that's really all that the exception seeks to do. And then in the other aspects, the court was saying, you actually haven't said enough. You actually haven't put up enough facts on these particular areas for the president to actually answer to this case in a legal way. And that's why the order was that the plaintiff, the Marikana workers, had to go and fix their papers within 6 weeks. So, I think at this particular point in time, we can only say that once actually we have a credible sort of case or at least once the case has been fixed, because that was what was ordered. So, that was the order that the judge gave to say, with respect to these parts of the exceptions, you have to fix the papers so that there is a case that can actually be answered in law.
So this part of the judgment was pulled, and it is quite scathing in a sense if you read it. It says the defendants were acting individually and collectively, and the allegations that the first defendant participated in masterminded and championed the toxic collusion between Lonmin and the South African Police Service, which resulted in the death, injuries, and arrest and the detention of Lonmin employees, including the plaintiffs. I agree, and it is accordingly my finding that the plaintiff has satisfied the test of legal causation. That sounds quite intense.
Yes, I think what the judge is actually saying there is that when you read those words, they set up a case for the president to answer. So the judge is saying, when we look at what causation entails, you've got to say that there was conduct, and in this instance, what the Marikana workers alleged in their papers was that the president colluded with Lonmin as well as the government, so there's your conduct, and that conduct then caused particular harm. So you've got to set out in a logical sequence those particular allegations. Whether the proof will satisfy it or it will be proved or not, it doesn't matter. But when you look at the papers cold, you've got to have those allegations in sequence. And that's what the judge is actually saying. He's saying, you have made enough allegations in the papers that would justify the president actually answering a case on causation, legal causation. So that's really what the exercise involves in this particular instance. There isn't a finding that the president has caused harm. There isn't a finding that, on the evidence, this is actually what has happened, that there was collusion. The court is simply saying the allegations that are there are in such a form that the president has a case to answer.
Yeah. And Mr. Nkome, you're saying that is enough for you in terms of what you set out to do?
Look, I think if I may assist my fellow panelists, we have got, if we were talking about this one aspect, this one exception, the one where the court concluded that Mr. Ramaphosa was a champion and he masterminded a toxic collusion between state and capital. Does he say that Mr. Ramaphosa is on this basis alone going to be required to come through to court? Or are we supposed to make some more substantiations? Because we have issued summons, he raised an exception, the exception failed. The next step is for Ramaphosa to plead to our papers, to tell us the reasons why he says he's not supposed to be held liable, and then we are supposed to go to court. We are not going to be going to court to substantiate any other legal factors or any other legal elements of the offense. So therefore, let's not confuse issues. In as much as the court has made an order that says there ought to be amendments, it's supposed to be amendments on those exceptions which have been upheld. And we will go through and amend those. But in respect of the one where we say Mr. Ramaphosa was a mastermind and he championed a toxic collusion between state and capital, it's not our baby anymore to go and prove the allegations because those have been proven. His objection was dismissed. and therefore he's supposed to come through to court and respond. So therefore, a case has been made for Mr. Ramaphosa in this instance to come through and be in the witness box and be cross-examined.
So a case, for example, around the duties that you said were owed to the employees by management, including Mr. Ramaphosa. You're saying you will no longer be going to make submissions on that anymore, on the fact that it's already failed at this point. So, for example, the other one that as head director, he owed particular duties to the employees, and the court saying, no, there's no way where it proves that he owes any duties to the employees. But as a director, of course, he owes duties to the company. You will not be pursuing that line in terms of your case anymore.
Indeed, so yes. Look, the court raised cases like Steinhoff, which essentially meant if we were to succeed in that respect, it would have meant that we would have held the rest of the other Lonmin directors liable for what transpired within Marikana. But in this instance, we were saying Ramaphosa acted in his own personal capacity because he was a shareholder of the operation and he was a director of the operation. He was also an NEC member of the ruling party, and therefore he was the sole person that was able to exercise and exert the kind of pressure that he exerted onto the police minister then, the then Minister of Mineral Resources, as well as other high-ranking politicians, to say, let's characterize this and let's make sure that the police acted in a pointed way. So therefore, just on that aspect, we will be able to have Mr. Ramaphosa into the box. And I think I'm hoping to hear on my fellow panelists to say, for the fact that exception has been dismissed, does it stop us or does it stop Mr. Ramaphosa from coming through to testify in court?
All right, Mr. Phiri, is a clean cut as that now the next move is on President Ramaphosa to respond to the papers that have been forwarded by the plaintiff?
Yeah, I think what Mr. Nkome is saying is true. In respect of the exceptions that were upheld, and if he's saying that they're not actually going to proceed on those aspects of the case, then, there is a concession that they're not going to amend the papers as directed by the court, and they're going to hang their case on the exceptions that were denied. So with respect to the exceptions that were denied, yes, the president and Lonmin has to then plead to the case that has been put forward in that respect. But that by no means suggests that, the facts, or at least the allegations that were put there, have been proved. And I think that's what's concerning from my perspective, is hearing that the allegations have been proved. The allegations have not been proved. We still have to hear what the president's defense is to those particular allegations, and then we'll go through an entire trial, which will then determine, whether the plaintiff or the respondent are successful in proving their allegations. So we're not at a stage where any allegations have been proved at all. We're at a stage where a court has said, well, with respect to this part of your case, you've pleaded this part correctly. And because you've pleaded it correctly, the other side then has to respond to that case. But we're very far from any allegations being proved at this particular point in time.
Yeah. The president accepting this particular South Gauteng High Court judgment, is that an indication that the president is saying, well, I'm ready to go to trial? Because there's no indication, I suppose, at this particular point that he will be challenging any aspects of this judgment.
I think what he's accepting is that, the vast majority of the exceptions that he raised were upheld, including around, personal liability, etc. So I think that is a good result for him in that respect. And I think he's probably feeling a little bit comfortable with responding to the piece of the matter that remains to be ventilated, because it's when you consider the number of exceptions that were raised and the piece that remains to be ventilated, he's disposed of a bulk of the case. Yeah. And it's exactly so. I think that's why he would welcome the decision of the court in that respect.
Right. Mr. Nkome, how are you going to get around that particular aspect? I think it's the exception number 4 of 5, maybe if I'm not mistaken. The plaintiff have failed to plead a case that a special relationship subsisted between the first defendant as a director of the second defendant, so as to require that the first defendant fiduciary duties owing to the company are also due to the plaintiffs. The allegations pleaded do not show that the first defendant owed the plaintiff legal duties and therefore cannot, in law, incur liability to the plaintiff in delict in his capacity. You seemingly failed to get President Ramaphosa to pay in his own personal capacity, which is something that you wanted to do.
Mr. Mhluli, I think the point that is made by my fellow panelist holds both ways, in the sense that he says, for the fact that the court says they accepted that there's legal and factual causation, does not mean that the case is proven already. And he also accepts the fact that that exception has been dismissed, and therefore Mr. Ramaphosa will be called ultimately to come and testify in court. Now, the same thing should be said about evidence that we will be able to beat once Mr. Ramaphosa is inside the box. Because we understand that, like, for example, I say there is evidence that we did not put in our plaintiff's particulars of claim, in our summons, but which will easily be able to go and prove to him once he's in the box. Like, for example, the secret recordings that says that it was known that the number of people that were supposed to die as a result of the massacre was 20 instead of the number that passed on. So that has not been put up. A trial is still going to ensue, and we'll be able to prove every piece of evidence in front of the court, so that that court, a trial court, can make a conclusion as to whether or not it finds Mr. Ramaphosa both guilty in his personal capacity or as a director. But we have been informed that that exception has been upheld. It doesn't mean that our case is weaker simply because we have not been able to prove, or we've not been able to win on all the exceptions that he had raised. It therefore says the case is continuing. He's going to be called to court and to come through and testify. Had he been able to succeed on all of the exceptions, the case was going to be dead in the water. It was going to be the end of it. And I take it that many people would be saying people can walk around being 6 foot tall and bulletproof and say that we accept the judgment as has been given. But if I were the president himself, I would not be saying I accept the judgment simply because it still leads me to go and testify at court. That cannot be disputed.
Gentlemen, we appreciate your time. Thank you very much for your intervention this evening, and that explainer, they're helping us out through that particular judgment. Well,